Welcome and welcome back, everyone. Thank you for joining us for the September 2019 installment of Bracewell's Environmental Essentials for In-House Counsel webinar series. As many of you know, we do these webinars every month as a quick update on timely issues in environmental law. And today we're going to be talking about the new Endangered Species Act rules and regulations. My name is Daniel Pope. I'm speaking to you live from our Austin office. More excitingly, I'm joined by Ann Navaro, my colleague in Bracewell's DC office. We're going to cover as much as we can about these new Endangered Species Act regs in the next 30 minutes. If you have questions as we go through the webinar, please feel free to type your questions into the comment box on your GoToMeeting or GoToWebinar screen. We'll get to as many questions as we can at the end of the webinar, and if we run out of time, we'll respond to those questions in a follow-up email with you. So thank you for participating in that way. On the next slide, you'll see our little note that this is informational. We are not creating an attorney-client relationship with you, nothing to fear. And tell us about these ESA regs.
Thanks, Daniel, and good morning, everybody, and thanks for joining us. We're going to talk today about an exciting development in the area of environmental law, and that's the promulgation of the final revised regulations implementing the Endangered Species Act. And probably most folks on the phone are aware that this has been portrayed as quite a big deal in the press because it's the first time in many, many years that there have been revisions to the regulations implementing the Endangered Species Act. So we're going to cover a few areas. We're going to talk about the primary revisions to the rules, as well as the practical implications and how they may affect you and the projects that your companies are implementing. And we're also going to touch briefly on climate change in the new rules, because that is an issue that has been of significant interest in some of the press coverage of the new rules. So first of all, just to set the stage for the new rules, the rationale for these revisions is very consistent with the approach that the Trump administration has taken from the beginning of the administration in the context of other major rulemaking efforts. The administration is looking to stay very true to the statutory text and not to stray far beyond those boundaries. And I think most importantly, the administration is looking to improve the predictability of the application of the law and of how agencies make decisions. And the administration is looking to create efficiencies in ways that permits and reviews and approvals are processed in order to facilitate private and public projects. As I mentioned, the rulemaking has been controversial in that a lot of folks have anticipated Trump administration attempts to roll back the protections of the Endangered Species Act. Folks have perceived it as politically driven. To borrow another Endangered Species Act term, perhaps that's really not warranted in terms of what actually has happened with the final rules. In fact, as I think you will see, for the most part, the rules seem to make some very common sense modifications to some complexities in the rules and to try to create efficiencies. In fact, it's my understanding that these rules have really benefited from the decades of career civil servant experience that both the Department of the Interior and the National Marine Fisheries Service have in terms of problems and challenges with implementing the Act. Of course, the devil's in the details, so the key may be in how these rules are ultimately implemented. Daniel, back to you.
Thanks, Ann. Just wanted to give a brief timeline of these rules. They've been in the works for quite some time now, really over a year, with the first proposal of the rules last summer on the 25th of July, the day after I took the bar exam. They were published in the Federal Register. In September, the comment period closed with close to 200,000 comments on these rules. And then we basically heard nothing for 11 months until just this past August, when the final rules were unveiled with their responses to comments and a few changes to how these rules are going to actually be implemented. It didn't take very long before the first lawsuit was filed in the Northern District of California by numerous advocacy organizations. This is really a who's who of environmental advocacy organizations. And I'll just pause right here to give you a little bit of what they're claiming these new rules violate. First, the plaintiffs are claiming that these rules have violated the notice and comment provisions of the Administrative Procedures Act. As revisions in the final rules are made, sometimes agencies may overstep, may add or incorporate a new provision of a rule that some plaintiffs may claim that they didn't give fair notice of in their proposal of rulemaking. So that's one of the claims that these plaintiffs have made. Additionally, the plaintiffs have claimed that the rulemaking warranted a NEPA analysis, and the services had invoked a categorical exclusion to avoid following through with those NEPA analyses. And then, of course, on the 27th of August, the final rules were published in the Federal Register. Their effective date is a month out from that, on September 26th. These rules will be in effect, assuming that there are no court orders preventing the rule from going into effect. This is a key question. In the past several years, we've seen nationwide injunctions go into effect from district courts, federal district courts all over the country. And so it'll be interesting to see if a nationwide injunction and a nationwide preliminary injunction is issued. Let's first look at some threatened species protections on our next slide. In the final threatened species rule, and can you kick it? There we go. Thank you. In the final threatened species rule, Fish and Wildlife Services have adopted a long-running National Marine Fisheries Service approach. When a species is listed or classified or reclassified, as threatened, endangered species protections will no longer automatically apply to the threatened species. Now, that may be a little confusing. I should give a little background on this, or a refresher as the case may be. Threatened species are not endangered species, but the services can take steps to protect them under the Endangered Species Act. Of course, Endangered Species Act protections, like no-take provisions and that sort of thing, are mandatory for endangered species. But what about threatened species? Well, in the past, before these rules, and I guess now until the rules become effective, the services have extended these protections, particularly the Fish and Wildlife Services extended these protections to threatened species by default, regardless of the needs of that particular threatened species. This has been called the blanket rule because you're blanketing the threatened species or covering the threatened species with all of the protections you would expect an endangered species to receive. It's a one-size-fits-all approach, in other words. After these rules, the Fish and Wildlife Service is going to promulgate species-specific protection rules tailored to the circumstances and the needs of that particular threatened species, instead of blanketing them with every protection possible. Now, the rule is only going to affect threatened species listed or reclassified as threatened after the effective date of the rule, so it's prospective. Protections that have been extended to threatened species before September 26th will still be protected by the blanket rule. But there are some efficiencies that the service is hoping to realize here. As it undergoes the analysis to identify whether a species should be listed or reclassified as threatened, it's going to be generating a lot of information. It wants to fold all of that information at the time that they're reviewing it into tailoring a rule that's going to protect a threatened species. Practical importance of this revision is that project proponents may be subject to species-specific rules, but the rules may afford more flexibility and entail fewer restrictions than the previous blanket rule. And of course, the species itself may be helped by having these specific rules be promulgated immediately upon review of the threats posed to that threatened species. Anne, would you talk to us about interagency cooperation and the revisions that we've seen there?
Thanks, Daniel. Before I turn to that, I just wanted to add a little bit of additional color about the threatened species issue. So the environmental stakeholder community generally is very concerned about this provision because even though it sounds logical and really sounds quite beneficial in terms of how individual species are dealt with, it's my perception that folks are concerned that the Fish and Wildlife Service, which manages by far the most endangered and threatened species as between the two services, will become, let's say, lazy, either purposefully or because of resource constraints, and in fact not afford any sort of protection to threatened species because they won't want to go through the process of promulgating a species-specific rule. So that's the concern, and I imagine we will see that play out to some extent in litigation. Turning to interagency cooperation, and this is probably the element of these revisions that is going to have the most immediate practical effect on the private sector when it is seeking federal approvals of any sort that implicate potential effects on endangered species. So interagency cooperation falls under Section 7 of the Endangered Species Act, which requires federal agencies in consultation with either of the relevant wildlife services to ensure that federal actions are not likely to jeopardize endangered and threatened species or result in the destruction or adverse modification of critical habitat. And so federal agencies have to take that into account and go through that process before issuing permits, leases, funding, project approvals of any other sort, easements, etc. And so I think as most folks on the phone who have dealt with that process know, it can be quite efficient and not a big deal. And of course, it can be very complicated and confusing for a variety of reasons. So I think based in large part on career experts who have a lot of experience with Section 7, the agency has tried to simplify its approach in some respects. It's also made some substantive changes that have real implications, and some of those are on this first slide. So in terms of critical habitat, the agency has altered the definition of what it means to destroy or adversely modify critical habitat to focus on critical habitat as a whole. So before, you might have had instances where the agency was really looking at the impact of an action on just a segment of critical habitat and finding destruction or adverse modification. But now it's clear that, much clearer, that the agency really needs to look at the impact on the entirety of the habitat. And then the agencies have also made modification to the definition of effects. So the question is, what are the potential for effects on endangered and threatened species? The agencies say in the preamble to the rule quite clearly that it is their intention to continue to include the entire scope of potential effects that have always been considered. However, the revisions to this definition are attracting some negative attention because some folks may perceive the revisions as potentially narrowing that responsibility. So, for example, the old rules required consideration of indirect effects, direct effects, interrelated activities, and interdependent activities. The new rule has gotten rid of all those very specific terms and is now defining effects as all consequences to a listed species or critical habitat if they would not occur but for the proposed action and are reasonably certain to occur. So what the Department of the Interior has said is, look, all those other terms created a lot of confusion, and people spent a lot of time trying to figure out whether it was interrelated or interdependent, or no, maybe it was indirect. So they've attempted to simplify that approach and also to require some certainty that the effect will occur. Also, importantly, the agencies have now defined for the first time the environmental baseline. And I think this is particularly significant in some contexts, even though it may not be particularly significant in all contexts. Because what they've done is clarified that ongoing activities that are not within an agency's discretion to modify are part of the baseline. So in other words, the agency should be assessing the proposed action against the world as it currently exists. And that can be important. I'm going to give you an example that's in some respects kind of a very federal example. But for example, with significant federal dams in the Northwest, there has been an ongoing debate about whether the existence of the dam has to be considered as part of the proposed action because it's continuing, or whether it is part of the environmental baseline. And that could have significant repercussions for how effects to endangered species are assessed and dealt with. So under this definition, in my view, it's now clear that the existence of the dam, which the federal agency does not have the discretion to remove, is very much part of the environmental baseline. Moving on to kind of more practical nuts and bolts every day, how is this going to really impact processing of permits, easements, et cetera, is the next slide. They've now codified the opportunity for programmatic consultation, which existed before, but in a much more informal fashion, I think leading some parts of the department to not want to use it or confusion. So this may be useful for recurring actions in particular geographic areas or for programs or policies that provide a framework for future actions. So one could envision the opportunity, for example, to have a programmatic consultation for areas of the country that might be seeing a lot of the same type of project or construction impacting the same type of species, which could create efficiencies for the private sector. For the first time, the regulations have provided a 60-day consultation deadline for informal consultation, and also provided clarity in terms of what the Fish and Wildlife Service and National Marine Fisheries Service roles are in determining whether formal consultation are triggered, as well as what is required from a federal agency. So currently, it's a very unstructured process where it's not often transparent to the private sector what the agencies are doing or what's required. So these regulations attempt to bring some transparency and structure to that process. Similarly, the regs clarify responsibilities for formal consultations and also have a provision to allow for expedited consultations for actions with minimal effects based on previous experience. Again, I could see that being relevant in a part of the country where there's a lot of ongoing project construction where the agency might be seeing the same kind of effects and dealing with it in the same ways over and over again. Also not on the slide, the regulations also revise in certain limited respects the requirements for reinitiation of consultation. The major change addresses a Ninth Circuit decision regarding when agencies have to reinitiate for federal land management plans. And I will hand it back to Daniel to talk about listing and critical habitat.
Thanks, Anne. I'm going to touch on a variety of revisions to how the services are going to be listing or reclassifying species. The first bullet here has been one of the more controversial and maybe one of the more misunderstood in my view. Agencies can now refer to economic impact in their listing decisions for informational purposes only. The agencies have been rather clear and pointed that any reference to economic impact in their listing decisions moving forward will be for those informational purposes, but I still see articles getting this wrong despite the effort of the services to be clear. it basically is a common sense rule that, as the services gather an immense amount of scientific and commercial data, they're going to be learning, even if they're not basing their decision on information about how a listing decision might affect commercial or economic activity in an area. The agencies have removed, via these rules, a prohibition on referring to economic impact at all. So again, to be clear, no economic impact can form the basis of any listing decision, but the agencies can refer to it when they issue their decisions. Agencies will examine the phrase likely to become endangered within the foreseeable future by making probabilistic and reasonable determinations about the eventual listing. These predictions will need to be reliable and grounded in science. I'm going to, in the interest of time, just touch lightly on that one because we'll be looking at it again when we talk about climate change here in a couple of minutes. The agencies have also listed several new delisting factors, or made some revisions to delisting factors, rather. And these delisting factors under the new rules will align the regulations with the statute itself. So, for example, the definition of recovery has been replaced with language that adheres to the statutory factors for listing instead of other kinds of factors that you could consider, but that aren't specified in the statute. Delisting a species is warranted if the species itself doesn't meet the statutory definition of species within the Act. Those are a couple of examples of the ways that the agencies have tried to realign these listing rules with the statute itself. As far as critical habitat revisions go, we've seen a modification of not prudent determination language within the CFR. It has been modified to specify circumstances in which critical habitat designations are not prudent. Again, aligning the regulations with the statute. If land fails, for example, to be critical habitat as defined by the Endangered Species Act itself, so not defined by regulation, but defined by the statute, a not prudent determination must issue. The agencies have also clarified when and how unoccupied areas may be designated as critical habitat for an endangered species. This was not in the proposed rule, but it's worth mentioning. The final rule has added a requirement that critical habitat must have at least one of the physical or biological features essential to the conservation of the species in order to be considered potential critical habitat. This follows on from the Supreme Court's unanimous decision in Weyerhaeuser versus United States, which held that critical habitat must first be habitat. I'm going to move on quickly to the next slide, and as we talk about the final rules and climate change, I mentioned just briefly the foreseeability analysis. Climate change models have been used to argue that certain species are threatened in the foreseeable future, but what future is foreseeable? These new rules have required that the best available scientific understandings be deployed in analyzing what the foreseeable future might be. There's been a concern that long-range forecasting or speculation may not constitute the best available science. Now, revisions to these rules about the foreseeable future and how it's to be analyzed was not driven inside the agencies by climate change itself, although most people recognize that that's going to be a source of climate change debate. There is a recognition that the foreseeability analysis may also be a battlefield for litigation as science is dragged again into the courtroom. But these rules themselves indicate that climate change science may be used in considering a listing, but climate change speculation may not be used. So we're unlikely to see forecasts into a century as a basis for listing. In other words, to simplify what the agencies have done here, we can see that the foreseeable future analysis is not hostile to climate change science, but it does demand that the climate change science be science. Regarding not prudent determinations, and this is where the services conclude that it is not prudent to designate a certain area as critical habitat, the services have concluded and will be and have revised their rules to indicate that critical habitat designations are not prudent or may not be prudent when climate change poses the primary threat to the species through broad impacts like sea level rise or glacial melt. In these circumstances, management decisions won't prevent climate change effects which are global in nature. And so climate change cannot, since management decisions won't be able to address climate change in that way, it may be prudent to not designate critical habitat for a species. Anne, can you give us your final takeaways on these new updated rules?
Sure, thanks, Daniel. We've been discussing kind of some practical implications of these rules in terms of how they will affect the private sector. Certainly one goal is for agency decision-making to become more efficient and more transparent so that there's less uncertainty in the consultation process as between a federal permitting agency and the Fish and Wildlife Service or the National Marine Fisheries Service as it affects the private sector. It obviously remains to be seen how that's going to play out, but there's certainly some opportunities in terms of the enhanced guidance given in the rule as to how the consultation process should work, the opportunity for programmatic consultations, the opportunity for expedited consultations. There are certainly opportunities to make the process more efficient. In terms of kind of substantive issues as opposed to process, I certainly foresee, assuming these regulations ultimately go into effect, I certainly foresee that the precise meaning of some of the new definitions, like the definition of effects, the definition of reasonably certain and what that means in terms of future activities, and the definition of foreseeable future, I certainly anticipate that there will be litigation that will catch private projects up in the course of that litigation over the meaning of those definitions. I think those definitions are also the types of things, though, that afford the agencies a fair amount of discretion. So in terms of how the new regs are implemented, I think we certainly may see them implemented one way in this administration, and then perhaps the same regulations will afford discretion for a slightly different approach in the next administration. And then the other critical thing, which is really related, is that these regulations, to me, appear to be a real attempt to kind of tie the decision-making to real, actual, and solid information as opposed to speculation about effects to species in order to facilitate decision-making and provide more certainty in the process. So it will be interesting to see how things move forward in light of the litigation already filed and more litigation to come. And with that, I will see if we have any questions. We don't have any questions this morning. Feel free to follow up with either Daniel or me if you would like to discuss this matter further. And please join us for our next webinar in October. And information about that webinar will be sent around in the near future. Thank you very much for joining us and have a great day.